interpretation services available. Therefore, the participants should find the language channel that best suits their preference. We would like to ask the speakers to speak slowly so that the translation can be done. In addition to that, we would like to tell you that in order to ensure the accessibility of this international human rights course, we provide the service of sign language. Throughout all the transmission, the interpreters will be available together with the speakers, thus allowing all the participants to have full access to the content presented. We hope you've enjoyed the previous days of this course. Truly speaking, they have been very interesting. Those that were unable to watch all the panels, please remember that they are recorded on the platform so that you can view them asynchronously in the function or section previous classes. Today's panel is entitled Forms of Labor Exploitation in Africa, Latin America, and the Caribbean. We will be joined by Quinn Kepes, Yesenia Diaz, and Antonio Rosa, very prestigious guests. This panel will look into the specificities of human trafficking with the aim of labor exploitation, taking into consideration the differences in the different territories or areas, urban and rural environments. We will also explore the issue from the perspective of public policies and also from the point of view of civil society, including the voice of trafficking survivors. Let's give the floor now to Quinn Kepes, who oversees programming and research of Verite NGO on commodities in the Americas, and he has researched on the links between organized crime and abuses to human rights. You'll be able to read his bio on the platform. Quinn, you have the floor and you have 30 minutes. Thank you so much, and we would like all the CIPDH team for the invitation for this space to share Verite's experiences. Today, I will be talking about the way in which forced labor occurs in the Americas. I will switch to English now.
Is in English, but any questions, happy to answer in Spanish. So, as I mentioned, we're really focusing on how forced labor is manifested in the agricultural sector in the Americas, based on decades of research that Verite has done. And so Verite is an organization that was founded about 30 years ago, and we work with governments, civil society organizations, and businesses to eliminate the most severe labor and human rights abuses from global supply chains. We're a nonprofit organization. We're based in the US. I'm based in Mexico, and we have teams across the world. Our work includes research and assessments. Prior to becoming the senior regional lead for the Americas, I was the practice group lead for applied research and been involved in research for many, many years, about 20 years in Verite. We also work on the development of tools and guidance, which is based on that research and stakeholder engagement and assessments and our work on the ground. We also carry out training for governments, civil society organizations, brands, and their suppliers, as well as social compliance auditors. And we do consulting for companies on human rights due diligence. And finally, we implement large multi-year projects which are funded by major government agencies and foundations. As you can see at the bottom, we work for a number of major international companies on a fee-for-service basis. And we also do large amounts of grant-funded work, again, by foundations and governments. And we work in collaboration as well with major international organizations, such as the ILO and the IOM. And the information that I'm going to share today is based upon many, many years of research that we've done in forced labor in the agricultural sector. Since 2008, really, with a grant from the US Department of Labor, Verite was actually the first organization to operationalize the ILO indicators of forced labor through research, through a project that was carried out in 7 different countries on indicators of forced labor, including in the Americas, in Bolivia, the Dominican Republic, and Guatemala. all focused on the agricultural sector. So over these years, we've carried out research on forced labor in the United States, Mexico, Guatemala, Honduras, Colombia, Ecuador, Peru, Bolivia, Brazil, and the Dominican Republic. And in sectors as diverse as fruits, vegetables, livestock, garments, coffee, cocoa, sugarcane, tobacco, and palm oil, as well as Brazil nuts, cattle, corn, and peanuts. So as you can see, there's really a diversity of different sectors and countries that allows us to come to some broad conclusions about the types of indicators of forced labor or practices that contribute to forced labor that we find in the region broadly. Of course, there are always differences by country and sector, but we don't have time today to go through each individual country and sector to explain what it looks like. So we're talking a little bit generally today about what we see. I'm also going to be talking today briefly to give you a conceptual framework about the definitions and differences between human trafficking and forced labor. We know that this course is focused on human trafficking, and forced labor is one of the purposes of human trafficking. But we're really going to focus today on the indicators of forced labor. And to do so, I want to talk a little bit about what the overlaps and differences are between human trafficking and forced labor. So first, it's important to emphasize that human trafficking requires three key components. According to the UN Protocol to Prevent, Suppress, and Punish Trafficking Persons, especially women and children, of 2000, which is known as the Palermo Protocol. So first, there's the act. You need the act, which is recruitment, transportation, transfer, harboring, or receipt of persons. You need the means, which needs to be through the use of threat, coercion, abduction, fraud, deception, abuse of power, or vulnerability, or giving payments or benefits. And finally, the purpose. So it has to be for the purpose of exploitation. And this can include for prostitution or sexual exploitation, forced labor, slavery or similar practices, removal organs, or other types of exploitation. So as I mentioned at the beginning, one of the purposes of human trafficking is forced labor. So there is an overlap there, but for human trafficking, you need that act and the means as well. So forced labor is one purpose, and therefore you can talk about trafficking for forced labor or labor trafficking, or sort of the two terms that are frequently used, and sometimes referred to also as trafficking for labor exploitation. So you can see that there's overlap there. Today, we're really digging into the concept of forced labor as defined by the International Labor Organization, which is a UN body that establishes legally binding conventions. So all the way back in 1930, the ILO drafted and a number of states ratified ILO Convention number 29 on forced labor, which they've defined as all work or service which is exacted from a person under the menace of any penalty and for which the said person has not offered himself voluntarily. So from the very beginning, it's clear that there are two elements to forced labor, right? So there needs to be involuntariness, meaning that the individual who is in forced labor did not offer themselves voluntarily to do this work. And there needs to be the menace of penalty. So there needs to be some kind of penalty for leaving that work. So again, you have sort of these two main elements that are very clear, and you need both of them to exist to have forced labor. It is important to note that the ILO definition excludes compulsory military service, civic obligations, or work mandated as a result of court conviction, as long as they're under the supervision of a government authority, and there are other requirements for that. The conditions of work should be commensurate to those in a free work relationship. And finally, some work in certain emergency situations. So as I go back again, the key components of involuntary work and threat or menace of penalty are essential for forced labor to exist. And many times we see the terms slavery or forced labor or trafficking tossed around without taking seriously what the actual definition is. And from our perspective, that really weakens the case for forced labor and can create lots of misunderstandings, as well as making it seem more superficial when an actual case of forced labor does exist. So you might just have somebody working at a factory with dirt floors, for example, and I've seen cases saying this is slave labor, and if the other elements exist, maybe it is slave labor or forced labor, but it's really important for us to stick to those definitions so that there's credibility for the research, and so that there's consistency in terms of how we're identifying and defining forced labor. So in terms of involuntary work, it's any work taking place without the free and informed consent of the worker, right? So workers need to be provided information, and they need to be free to decide whether or not they want to work under those conditions. So this can, a lack of voluntary work or involuntariness can include work taking place under deception or work in which workers are not informed about the conditions of work. On the other hand, threat or menace of penalty can include a wide range of penalties. It can include coercion or threats of coercion, or witnessing coercion imposed on other workers. And importantly, it doesn't have to be, workers chained up, workers being, physically harmed, which is sort of the conception of forced labor. In many cases, there are more indirect forms of coercion that are invisible and require speaking to workers to understand if they're present in practice. So in terms of questions to consider when speaking with workers or observing a situation, you need to ask yourself in terms of involuntariness, has the worker entered into a job of their own free will and based their decision on accurate information provided without deception? If not, there may be involuntary work, which is one of those elements of forced labor. You also have to ask, can the worker leave the job freely without threat or punishment to themselves or their families? If not, there may be threat or menace of penalty at play that prevents the worker from leaving. And if both of these elements are present, then forced labor may be present. And it's very important to understand each of these individual elements. So in terms of identifying forced labor, the ILO has done something that's been extremely helpful, which is that they've created indicators of forced labor. So these indicators of forced labor went back to 2008, they've identified a series of different indicators. Because it can sometimes be challenging to identify involuntary work and threat of menace or penalty, and therefore to identify forced labor. So Veritas actually, as I mentioned, since 2008 has been working on research on indicators of forced labor in the field to identify cases of forced labor, and we're the first organization to operationalize these indicators in this kind of in-depth research. We've actually used each one of these iterations of forced labor indicators. So back to the 2008 indicators for identifying forced labor in practice, the hard to see, harder to count indicators of 2012, the International Conference of Labor Statistician Guidelines concerning the measurement of forced labor of 2018, and the most recent hard to see, hard to count indicators, which were launched in 2024 in this year by the ILO. This presentation, I'm going to present findings related to the 2018 ICLS indicators. And the reason is that the vast majority of research that we implemented was implemented using those indicators. And because there have been some changes of the indicators for these new 2024 indicators, I want to make sure that I'm presenting on the knowledge that we have and specific indicators that we investigated. However, we are and already have integrated the new indicators into research that we've done. So we always try to use the most recent indicators. However, it's important that the ILO has stipulated that indicators can be used inter alia, meaning that you can refer back to previous versions of indicators. Sometimes we see indicators appear or disappear. For example, for the 2012 ILO indicators, we had an indicator that was the threat of penalty of supernatural retaliation, which has disappeared from subsequent versions of the indicators, but we actually find can be, pretty powerful in some cases. So, in illegal gold mining in Peru, for example, where I carried out research, we found that people were legitimately scared of of supernatural retaliation, curses that could be put on them, and it was something that dissuaded them from leaving their jobs. And so, forced labor is a very psychological phenomenon, and that's important to remember throughout this presentation. So forced labor indicators help to identify the presence of involuntary work and a threat of menace of penalty. So what I'm going to do now is really go through each of the indicators of both involuntary work and threat or menace of penalty. And I'm going to talk about how those indicators are manifested in practice. So it's important for me to do this for a couple of reasons. One reason is to really do away with some of the myths about what forced labor looks like. And two, to help the audience potentially to identify forced labor in the work that they're doing in the agriculture sector in the Americas. So in terms of involuntary work, we see 9 different indicators here. And so I'm going to go through each one of these indicators and talk about how this might appear actually on the ground. There are a couple of other indicators that aren't present in here, such as work for different employers or work with changes in working conditions that are under the second, that are very similar to the second indicator. So just don't have time to go through each and every one, but there are 2 more indicators that you should take note of. So first, in terms of unfree recruitment at birth, through transactions such as forcible recruitment or bonded labor, it's important to know that this is actually the indicator that is most associated with slavery or forced labor, but is actually the one that we found to be least present in agriculture in the Americas. So we see, in countries, for example, like India or Pakistan or Sudan, we do see some cases of generational forced labor where people, for example, in Pakistan, might be born into sort of generational debt in brick kilns. And I have also done research in different countries in Africa over the years, but we aren't going to be touching on that work, just too broad to generalize across the world. But we do see this kind of being born into forced labor in some cases. In the Americas, we really see it very infrequently. We did see in some families in Bolivia, for example, in that research back in 2008, individuals on cattle farms who might be born into intergenerational indebtedness. But other than that, we don't tend to see this kind of indicator of unfree recruitment at birth. A situation in which we see very frequently is situations in which workers must perform a job of a different nature from that specified during recruitment without that person's consent. And so this happens, under a number of different scenarios. So in many cases, it has to do with the use of third-party recruiters, with labor brokers. And in these cases, we find that in many cases, labor brokers are incentivized to deceive workers about their conditions of work. They may be paid, for example, according to the number of workers recruited. And so in order to get workers to accept jobs, they may deceive them about their conditions of work. They may also receive a percentage of workers' incomes. And again, they have the incentive to recruit as many workers as possible in order to increase their earnings. So we see, just the deception about the conditions of work. We see deception sometimes about the employer, which is another type of indicator. And sometimes we see cases where workers are even recruited to work in a different sector. So there was a case in Guatemala, for example. We were doing research in the sugarcane sector, and we found that recruiters would go to workers' communities of origin and indigenous communities in the highlands and show them a branch of ripe coffee cherries. And they say, we have, the coffee is ready for the picking. We'd like to recruit workers to work in coffee, they would transport them in buses, and they would transport them to a sugarcane plantation, which is much more dangerous and physically demanding work. We also saw cases in which, when we were doing research in the coffee sector, they would go to workers' communities with a branch of ripe cherries, say that the coffee is ripe for the picking. And when the workers got to the farms, they'd find that the coffee actually wasn't ripe. This was from another farm. And it meant that workers, in many cases, because they get paid by the amount of coffee picked, they could only pick a little bit of coffee at the beginning. And this was beneficial to the farm owner because if you don't pick the first ripe cherries, the coffee rots on the vine. In practice, we found that the workers could become indebted during the first few weeks of the harvest while they're not able to harvest a lot of coffee because they have to buy goods at credit from company stores. We also find on the next indicator, abusive requirements for overtime or on-call work that were not previously agreed with the employer. So sometimes workers are simply told, you have to work overtime. And if you don't, we're not going to pay you as much, whatever it is. But what we find to be more common is, again, related to this piece rate pay. So being paid according to the amount that workers produce or the number of tasks completed. We're actually, within the next week, going to be publishing two white papers, one on piece rate pay and one on recruitment practices as root causes of labor violations in the coffee sector across Latin America. And again, we find those problems with recruitment around deception and piece rate pay to be root causes of a number of different issues. So in terms of abusive requirements for overtime, we find that because workers are paid by according to the amount of coffee harvested, and many times there are also quotas, production quotas or targets that are imposed on workers. They may have to work long hours in order to earn enough to survive. Or there may be penalties for failing to meet production quotas, such as not being paid their wages, being paid fewer wages. We found cases in which workers aren't given transportation back to their homes until later at night after they've worked well over 8 hours per day. There are times when workers aren't given their meals if they haven't met production quotas. So we find that these practices contribute to forced overtime. And additionally, if workers are paid according a piece rate, we almost never find that piece rate is increased during overtime hours. So workers aren't paid overtime premiums, right? So in many countries, laws require, for example, workers who work overtime to be paid 50% more during overtime hours. But if they're paid a certain amount per 100 pounds of coffee harvested, they're not provided 50% more during those overtime hours. We also find many cases in which workers work in hazardous conditions to which they have not consented, with or without compensation or protective equipment. So we find many different workplace hazards, from the presence of venomous snakes on plantations, to use of sharp tools, to working at heights, to exposure to pesticides, to working under the sun for long hours without shade or water. And in sectors like the sugarcane sector, they've actually documented that this causes chronic kidney disease of unknown origin, which is a lifelong lethal condition that affects large numbers of workers in sugarcane. We've documented it in outside of Nicaragua, where it's been widely documented, and the more focus is on construction workers in the Middle East. But we've seen, especially with climate change, that this is only getting worse. And so in many cases, again, during recruitment, the workers are almost never in the agricultural sector in Latin America provided with written contracts. In many cases, the verbal contracts that they have don't actually describe the conditions of work. Sometimes we ask workers, do you have a contract? They say yes. Is a written contract? No. Is a verbal contract? Yes. So they just explained to me what that, for example, I'm not able to leave the farm until the end of the harvest season. That might be the only thing that they consider is in their verbal contract, but there are no guarantees. In many cases, there is little or no explanation of what their conditions of work will be, and what the risks will be. So often there's no consent, and workers are not provided with personal protective equipment or training to protect them from these health and safety risks. We also see work with very low or no wages very often. Again, lots of this is connected to piece rate pay. So um, if workers are paid according to the amount of coffee harvested, for example, they are not guaranteed the minimum wage independent of production. And in many cases, the minimum wage is far below the living wage. So we find in some cases that workers are, well over 90% of workers are earning less than the minimum wage. In many cases, also through piece rate production, you have whole family units who together are earning less than one minimum wage. And this also means that many cases, women and children aren't provided with their earnings. The only person who's considered an employee, even though they don't have a contract or benefits, is the male head of household. And in many cases, the wives or domestic partners don't receive any compensation for their work. The man receives all the compensation. And this leads to gender imbalances and can also make it difficult for women, for example, to flee from situations of domestic violence. And in some cases, we do see wage withholdings as well. For example, some workers aren't paid until the end of the coffee harvest, which is also a way to retain them on the farms. We also see degrading living conditions imposed by employers, recruiters, or other third parties. In many cases, migrant agricultural workers live on farms during the duration of their employment. And in many cases, the conditions of work or the living conditions are even worse than their conditions at home. So when we do research, many cases we ask what the decent living condition deficits are. So do the houses have electricity, sufficient space? Do they have running water? Do they are there hazards in their living conditions? Are there walls? Lots of times workers live in galeras with open sides without any kind of protection from the elements. Lots of times workers live on sleep on the floor or on dirt floors. In many cases, workers are provided with very little food. And it's really interesting when we do worker interviews. One of the things we do is we ask workers, what will be your biggest priority for changes in your working or living conditions? In many cases, workers' main priorities are around living conditions. We have workers who tell us, could you tell our employer we want a piece of cardboard to sleep on the floor? It's very cold and the moisture penetrates our clothes when we sleep directly on the dirt. Or can it tell our employer that we want them to cook our beans well? They give us these hard beans, and a refrain that we hear lots of times is "No somos animales." We aren't animals, right? And so it's this degrading nature where it's not just saying compared to where we might live in a privileged situation, do we consider this degrading? No, we ask workers, are these worse than your living conditions? And we interview workers in their communities of origin, and we see high levels of precarious living situations. We see high rates of malnutrition, but workers in their workplaces are living in even worse conditions and provided with even less and less nutritional food. So lots of times just beans every meal for 3 months, right? And beans that aren't well cooked. We also see work for other employers than agreed, and in some cases. So I mentioned that case of workers being recruited to work in coffee and being transported to sugar cane plantations, but we also see in some cases, for example, a worker might be recruited to work on a farm and then is also told to work in domestic service for a neighbor, for example, during that time, or in the farm owner's house, especially for women and girls. We also see work for a longer period of time than agreed. And so in many cases, workers, there are lots of labor shortages now in the agricultural sector, not only in countries such as the United States or Chile, but we see lots of different countries where labor shortages have emerged, which are historically sending countries for migrant workers. So we see huge labor shortages, for example, in the Honduran coffee sector, where you even have workers from Guatemala and Nicaragua migrating to Honduras, which is a country with even higher rates of poverty and violence in those two countries. And they're in an extremely precarious situation. And in many cases, the the farm owners may invest in recruiters, for example, to recruit those workers and transport them to the farms, and they try to recoup their investment by forcing workers to work the whole harvest season. Or in many cases, we see the use of what they call 90-day contracts, right? And for some reason, this sort of 90 days is quite common across the Americas, not only in agriculture, but also in illegal gold mining, for example. And workers are through coercion, forced to work out the duration of their contracts. We also see work with no or limited freedom to terminate the work contract. Again, I will get into some of those elements of coercion, but it may be through retention of wages. It might be through threats. It may be because workers are physically isolated and unable to leave. So I'm going to now go through the indicators of threat or menace of penalty. So we have, similar to the last slide, we also see the threat of or violence against workers. It's in many cases being the indicator of threat or menace of penalty that we see to be least common in the agricultural sector in the Americas. And so we do see, some cases of workers, being threatened with violence, but it's not especially common. What we see more often is sort of indirect threats of violence, or we see situations in which there's such a high level of societal violence and power imbalances and impunity that workers may be so fearful that they will not leave their places of work. So, for example, we've seen in Guatemala in the palm oil sector. We did interviews with workers who had worked on a farm that was owned by one of the key operators of the Sinaloa cartel in Guatemala. And they knew who that person was. And they were indebted to a store on the farm and told they couldn't leave before paying off that debt. And they said, we know what happens to people who don't pay off their debts, right? They didn't even need a direct threat. They just knew who the person was. They knew that they were capable of exercising violence, that they had exercised violence in the past, and that they weren't going to leave that situation. We also have situations, for example, in Chiapas, right across the border, in Chiapas, Mexico, right across the border from Guatemala, where we interviewed Guatemalan workers who had been employed on coffee farms and there's such high levels of violence against migrants, for example, and presence of organized crime, that workers were told by their employers who sort of leveraged this high level of violence, look, if you want to try leaving, you can try leaving, but something's going to happen to you, right? You're out on your own, and there's all these dangerous criminals out there, and you can face that kind of threat. We also saw a situation, for example, in the United States, where I interviewed workers who had been employed in Connecticut and were actually living in New Haven, Connecticut. It's the richest state in the United States. It's a relatively safe state, but they were told that there were gangs on that street, and that if they left their stoop, the stairs that they were sitting on, that people would harm them, and that they didn't like Latinos. And so it was interesting because there was actually a woman who was from a church who invited them to the church service, and they said, "Sorry, we can't go; it's too dangerous." That realized this situation was something was wrong here, and notified the authorities. So there's all types of different threats that can be used. It's not always a employer beating a worker or threatening to kill them. It can be these types of indirect threats that can also happen. We also see restrictions on workers' movement, and maybe this icon is sort of feeding into the impression that workers are chained or physically restrained. We've seen this in some cases, and actually there was another case in the United States where this labor recruiter Moises Rodriguez had actually kept workers in a chain compound. When workers escaped from Colorado, he tracked them to North Carolina on the other side of the country, beat them with a pistol whipped them, and brought them back. So that's an extreme case of, again, violence and physical isolation or restriction of workers' movements. But we generally see other more indirect restrictions on workers' movement. So one we see the presence of armed guards in many cases on farms and plantations.
Muchas
And we
veces
also,
en
in
plantaciones
some cases, those
y
armed
en
guards might have
establecimientos agrícolas
instructions. They
hay
might have instructions to
guardias
to
armados
check
que
with
pueden tener
management before
instrucciones de
allowing
controlar los
workers in.
movimientos, o
And workers
sea,
who are indebted or have
verificar con
their contracts might not
con los gerentes,
enable
con
to
los
leave.
jefes a ver si
But
pueden
more
dejar salir
commonly
a
than
los
that, we
trabajadores
see
o
that
no.
workers are
Pero lo
simply
que vemos es que
extremely
los
isolated,
trabajadores están muy
they may be working
aislados.
in very, very remote locations without public transportation. If their wages are retained, they might not have money to pay for transportation. They may be migrant workers far from their homes, and you can't just walk out into the middle of the wilderness. In the United States as well, I remember interviewing two Chilean brothers from Patagonia who had worked on a cattle farm, and their plane ticket home was retained, for example, by the employer. The employer supposedly paid them, deposited money into their accounts, but retained their ATM cards. And the two brothers, laughing, were telling me how over months they saved up gas for a lawnmower. And one day they finally got up the courage, and they filled up they took all the containers of gas and put their two dogs on the lawnmower and drove off over the mountains, miles and miles and miles, to flee from the situation of forced labor. There are also cases of debt bondage or manipulation of debt. And so it's really important to note that internationally, there's a lot of focus on recruitment-related debt. And so we do see workers paying recruitment fees or related costs to secure jobs in the agricultural sector. But usually we find those are maybe a day to 3 days worth of wages. And more so than recruitment fees, it's related costs such as transportation. So it's not, we've done research, for example, in the Malaysian electronics sector, where workers are paying on average about a year's worth of wages. So they have to work for a year before just paying off that recruitment related debt. The only case where we saw really, high levels of recruitment related debt are for the United States, where we saw, for example, Thai workers who were paying up to $27,000 for a 9-month work visa. So they were told that this was an unlimited visa, that they could stay in the United States permanently. There was deception. In Guatemala, for example, we saw that workers who migrated to the US, they actually had to sign over the deeds to their land. And we found workers who had to get money from Western Union from their families in Guatemala to eat because they were paid so little. So we do see some cases of those extreme cases of debt bondage, but those are usually for international migrants going to countries like the United States that are very hard to get into. When we have internal migrants or migrants traveling from one Latin American country to another, we generally don't see a huge level of debt related to recruitment. What we do see to be common, one is the use of enganches, right, of advanced payments that workers have to pay off through their work and aren't able to leave their jobs until they've paid off those debts. And that's very common, especially, for example, in the Mexican sugarcane sector.
Quinn, discúlpame, tienes 2 minutos para cerrar.
Perfecto. Solo tengo este último diapositiva y ya termino.
Fantástico.
And the other case is that we find to be most common is company stores. So we find that workers are not provided with sufficient food or, for example, medications, and they have to buy these goods on credit from company stores without any kinds of receipts or records of their debt, and aren't able to leave before paying off that debt. And that's very common. It's something that's sort of associated with sharecropping that people think is in the past, but this is still very present in the agricultural sector. We also see withholding of wages. So many cases, for example, workers are not paid, according to the law, they might have to be paid every two weeks, but they're paid every month. So they're not going to leave before, receiving those wages, because they'll have just wasted their time. In some cases, they're retained for their whole 90-day contracts or the whole harvest season. That's generally sort of the types of withholding of wages that we see. There was also that case I mentioned. They might deposit the money, but they don't, or they aren't actually able to access their accounts, or they're paid by a check, but they don't have access to a bank. And so they don't have the financial resources to actually leave. We also see the withholding of valuable documents. So this is also associated with international migrants. So it's usually sort of the assumption that internal migrants, they don't retain their wages. They only retain passports. But actually, we see that retention of other types of identification documents is also very common. So, for example, cédulas in Guatemala or DPI, the Documento Personal de Identificación, it's very expensive and time-consuming to get these documents back. So we had a lawyer, for example, who was part of our research team who was assaulted and robbed. It took him as a lawyer, with high degree of education, fluent in Spanish, a year to get a replacement document. Imagine an indigenous worker from a rural area in the highlands, right? There's lots of times bribes they have to pay, there's delays, they may not be fluent in Spanish. So, and workers without their documents can't access bank accounts, they can't make legal complaints. So this can be a very powerful tool to retain workers' identification documents, including internal migrant workers. In Brazil, for example, there's a document called the Carteira de Trabalho, which is sort of a record, it's sort of a formal resume that details all of workers' work experience and is also important for accessing Social Security benefits. So we see that document as being very powerful and important and being retained as well in the Brazilian context. So employers know how important these documents are, and that's why they retain them. We also see abuse of workers' vulnerability through the denial of rights or privileges or threats of dismissal or deportation. So you see, for example, workers' meals being taken away if they don't meet production quotas. And again, in the case of the United States, it's interesting because the US has been very critical of what they call the kafala system in United Arab Emirates and Qatar. But actually the US H-2A and H-2B visa system creates the inherent menace of penalty of deportation for leaving a job, even if their rights or the conditions of their contracts are violated. So if workers have no job or visa portability, so if employer is abusing them, if they leave that employer or try to switch to another job, they are automatically subject to deportation. So that is frequently used as a threat for workers not leaving their jobs. Or we've seen cases in which employers actually say, for example, in the United States, I interviewed workers who said that U.S. Department of or the local Department of Labor inspectors interviewed them because there had been a complaint about working conditions, and they were actually told by their employer, these are from La Migra, these are from the immigration department, and if you tell them that that your conditions of work don't match those of that were described during the visa interview, they're going to deport you, right? And so those kinds of threats of deportation are frequently used. And finally, the threat of dismissal and blacklisting is very common. And so especially in combination with blacklisting, telling workers that they're not going to get any job in a specific sector, for example, can be very powerful as well. So that's it. Thank you for your time. And you can see my contact information here. Happy to answer any questions, and please do write me if you want to follow up.
Muchas gracias, Quinn, por esta exposición tan ilustrativa de lo que es el trabajo forzoso. Ahora vamos a darle el piso a Yesenia Díaz. Yesenia es activista de derechos humanos, colabora con la Survivor Alliance y la organización no gubernamental Fundación Libera. Podrán leer su biografía completa en la plataforma. Adelante, Yesenia. Cuenta con 30 minutos para su exposición. Con muchas ganas de escucharte.
Muchísimas gracias, Jaime. Muchas gracias al CIPDH por esta gran invitación. Es un honor estar acá aportando, exponiendo lo que ha sido nuestro caso como sobrevivientes de trata de personas. Yo fui víctima de trata de personas sobrevivientes de este gran delito, desastroso delito. Soy venezolana, radico en Chile, tengo años en Chile desde el 2018 y ese mismo año fui víctima con más de 50 personas también que son
Together with more than 50 migrants, we are victims of human trafficking due to forced labor in the agricultural sector. We started working for the harvest, and we were victims of a deceitful labor offer. We were taken from the north to the south of Chile, working in different places
la fruta blueberry, ¿ya?
working with the harvest of the blueberry,
Empezando el trabajo con amenazas,
and we were under threat, we were menaced,
fuimos explotados,
we were exploited.
trabajábamos 10 horas
We
diarias,
worked for 10 hours a
otras
day.
veces trabajábamos hasta 12 horas, trabajábamos
Sometimes we
de lunes a
even
viernes.
worked 12 hours from Monday
La
to
comida que nos
Monday.
daban eran comida
The food we were
descompuesta,
given, I mean, was
en una
rotten.
parte hasta
In
no teníamos agua
many
potable tampoco,
places, we didn't
no
have
podíamos
drinking
escapar,
water,
no podíamos
and we could not
denunciar, no
flee, we
podíamos
could not
hacer nada
escape,
porque
we could not file any complaint because we were under menace because of the fact that we didn't have the papers, the documents to remain in Chile. This is a very sensitive issue for me. I'm sorry, I'm quite nervous. Truly speaking, it is very important for me that every person that is participating in this training course can understand what this crime means and how it affects us as migrants, because we are forced migrants. In fact, we leave our countries in a forced manner. It's something very tough. It's something very terrible because you are living in a country that is not yours. You need to fulfill, to comply with the law. You're looking for a job opportunity in order to take care of your family, to have access to healthcare and security. And you meet persons and contractors and employers and companies that commit this crime. And that's their work. I mean, it's incredible how they damage our lives. And not only that, because we are considered labor slaves. We don't have any health care, no social security, no pay. We have no privilege. We are entitled to no right, just for the sake of being migrants. And we had to work. Not only because of that, but as we are in touch with other people, with people surrounding us, with nationals, and being subject to that approach. I mean, they considering us migrants, looking down on us. And we are there working correctly for the employers and for all the others. And they are committing a crime because we are victims of labor exploitation. However, the nationals believe that we are depriving them of their jobs. And that's not the case. We did not come here to deprive anyone of their job. We are looking for an opportunity. We flee our country to have a better opportunity to be able to live, to survive. And in this case, in our case, this happened in 2018. We were victims of human trafficking. All the indicators mentioned by Quinn were present there. Justice was not done. We have been struggling for many years. We filed a labor complaint, however, we never compensated, no reparation was made, and we are still struggling to file for a criminal case. We are still struggling, fighting, supporting people, trying to find a way out so as to stop people from being victims of this crime. It is very important to know what is happening here. This is very serious because it not only jeopardizes the whereabouts of millions of migrants that want to do things right, who are looking for a chance and opportunity. Furthermore, it is important for people to know that if this crime is normalized, not only the individuals, I'm sorry? I get interpretation in this channel, but we can hear you very well. but I was able to hear the interpretation. Then, not only are we in danger as migrants, but the labor, the work of the nationals is also under stake. The people that belong to or live in that community, because most of that forced labor, most of this exploitation, the human trafficking, it occurs in rural areas. Then there's lack of communication, they get no information, there's no internet available, and people are unaware of what is happening. I will give you an example so as to make myself more clear. I mean, we were working in sites that were remotely located, very far away from the cities, and people living nearby thought that we were taking their jobs away from them. And in fact, they did not know that we were being slaves. We were being subject of human trafficking. We were exploited. Why? Because they did not know that this crime existed. And what's the point? I mean, we were not only victims, but we were also victims of discrimination. We are not only victims of human trafficking, but we're also victims of discrimination because we were in touch with people from that country. Just by listening to our voice, they would look down on us. Or they would tell us, go back to your country. You came here to take our jobs away from us. And therefore, you are not only a victim, but you are also discriminated at all times. Then you feel the burden. You were exploited. You were being a subject and a victim of human trafficking, and you were discriminated for the simple fact that you did not belong in that country, that you're coming from another country, that you were forced to migrate. Is it fair? It's not fair, but I cannot lay the blame on the person who lost her job because I got there to work, because the employer prefers committing a crime, making of this crime a job, and enslaving us and depriving the jobs or depriving the nationals from their jobs who need to change jobs for the simple fact that we are being enslaved and working there. Who's being enriched? The migrant who's working? No, the employer. The employer is being rich. The contractor is the one who's making money. The person who's subcontracting us, who's offering this service, that is taking the jobs away from the nationals to hire migrants who's contracting migrants to work as slaves, because first they deceive us, telling us that we would get the documents to work legally in the country, and then they threaten us that we will get no IDs if we file a complaint or if we leave. And many other threats and menaces that people are subject to. Therefore, the person who lives in his community in the rural sector close to work has to migrate because he cannot get a job because we have replaced for them. And of course, they cannot contact us. They cannot be contact with migrants. Therefore, that people are full of hatred. They feel that they have been dismissed because migrants are working and have replaced for me. However, they don't understand that the employer is the one who offers the jobs. The contractor is the one offering the jobs, the company. We don't get there and say, well, let's get all these people dismissed in order to work in their place. That's not the case. Therefore, the lack of knowledge and information, being unaware of what is happening, makes us victims of trafficking and discrimination.
And the hatred of those nationals, those that are in their country, is for a reason. Why? Because foreigners are taking away our jobs. We don't have any jobs because they are taking them away from us. And that is not right. I mean, there's a backdrop to all of this. So there's far more production to export. But there are fewer sources of work for nationals. I apologize because I'm a little bit nervous here. So I hope that you really get to understand what I'm trying to convey. Yeah, you're doing great. Do not worry about it. Everything is coming across perfectly. So thank you very much for your support. Thank you so much. I love it that you're with me because I know that I'm not a professional. It's not that I have a lot to contribute from an academic standpoint, and I love to hear all this valuable information from these experts that have studied and have taken the commitment to help people like us. So, what do we ask for? Not only do we ask for justice, not only do we demand justice because we do demand it, we've received no justice. Under 1% of human trafficking survivors have seen justice. We haven't seen justice, not in criminal proceedings, not in labor proceedings. We haven't even had the chance of our day in court in a criminal proceeding. So what do we claim? We claim for awareness, for good oversight. Those in power, those holding positions of power, should have adequate training. They should take an interest in this topic. They need to understand what this crime is all about because this is becoming so normalized that there will come a time where where a worthy job will no longer exist. If we keep normalizing this crime, a fair job will become a privilege, and that shouldn't be the case because everyone is getting used to outsource personnel, having other staff that are only working indirectly for the company, only working indirectly for the plantation, for the ranch, that they keep on reducing costs because people are not being paid because they are human trafficking victims and they are not receiving any compensation. They don't have the necessary health conditions. They are working 10 to 12 hours a day, Monday through Monday, the way we used to work, because we used to work Monday through Monday. And all we earned was discrimination and being exposed to the elements under threat of deportation, under threat that we wouldn't get the documents that we need in order to stay in the country just because we were migrants. Is that fair? Of course it's not for anyone. So the message I'm trying to convey here to anyone out there that is interested in this, we should all realize that this is not only a crime against migrants. It's a crime that victimizes every single one of us, whether directly or indirectly. We are all victims because those that lose a job in a company that is now using human trafficking victims, they are forced to migrate elsewhere, go farther away from their homes, and they can no longer work comfortably close to their homes. So these people that hate us are also victims, but they are indirect victims. Because once there is exploitation, once there is human trafficking that leads to labor exploitation, people can no longer enforce their rights. They cannot claim for any benefits. They cannot have worthy labor conditions. Why? Because there is a lot of human trafficking victims that are going to do their work. So if they don't like it, there's the door. Excuse me, she's cutting off. So these are not the only victims. We are not the only victims. Just like many others, I believe that we're survivors and that we have been victims to human trafficking, but we are not the only victims. I'm convinced of that. So and there's no way to know that because states are committed to these laws. And although they should be disseminating this information, they don't provide the proper training for the people in office to be able to identify these crimes. And it is often the case that people in power are actually covering up these crimes because I've also been there. We did not only suffer at the hands of private companies, also at the hands of those in power that treated us as slaves. We were animals because we didn't even have access to drinking water. We received food in poor condition and we had to work endless hours. We apologize from the booth, but she's cutting off. So what we need is training for those in power, for them to understand how to grant visibility to this and how to prevent these crimes. But that is not all. We only need to raise awareness on the community as a whole. And there's another extremely important thing, which is to report these crimes. We need readily available reporting mechanisms because this crime take place every day, but no one knows how to file a report. How will a person file a report if they do not understand these crimes? Many people just hate the migrants, and they hate migrants because they took away my father's job, because they took away my job, because they took a family member's job. So what do we need to do? We need to take this information. We need to bring this awareness. We need to make sure that the whole community, that all stakeholders understand this clearly because they are not getting the right information, particularly in the rural areas. We need to get the community to understand what's going on. They shouldn't be hating migrants. They shouldn't be hating anyone. They should be claiming for justice. Why were you voted upon? Because they just why were you kicked away from your job? Because they brought 100 migrants. But no migrant will know the job better than a person from the community that has done that their entire life. And every time they export a fruit, buyers are becoming more and more aware of this crime. And every time I eat fruit from Chile, from Brazil, from Peru, from wherever it comes, they become more aware of this. And we need to keep on raising awareness among our own communities, in our own countries, everyone in power, so that everyone understands this crime. And if we let this crime become normalized, worthy working conditions will no longer exist. And there are going to be millions and millions people exploited, not only human trafficking victims, because a slave is now doing your job. So this is not only about migrants, it's about those that lose their jobs to a human trafficking victims. So we are all victims, whether directly or indirectly. And not knowing, ignorance does not remove our responsibility for this. So please continue to raise awareness. and I would like to appreciate this space. I would like to apologize for many words that you may not have understood, and we're still waiting for the change. We want people to become more empathetic, and we cannot normalize this day after day. And the best way to stop this is to train these people and to make sure that everyone collaborates to put a stop to this. And I apologize for everything that was not understood. And thank you very much. You are doing great work, and it's a pleasure for me to be sharing this space with you. Thank you very much to you. Just know that we got many messages of people congratulating you and saying how much they value your courage in sharing your story. And I personally found out very moving. And please be aware that you have a lot to say and that your voice is fundamental for those of us working in the field to eradicate modern slavery. It's always essential to hear your own voices and to know that we are working for people. So let me say goodbye to you with a phrase that I heard from an attorney. When someone is weaker than I am, abuse is forbidden. And this is a principle of labor law. So let's not abuse anymore. Thank you very much, Yesenia, for your activism, for your advocacy, and you are always welcome. And right now, let us move to the last presentation on this panel. And we're going to give the floor to Antonio Rosa, a coffee project director in Brazil. And he worked for the ILO for 15 years, coordinating regional and national projects in the promotion of worthy labor conditions, social dialogue, prevention, and a fight against forced labor, human trafficking, and child labor. You can have access to his whole bio on the platform. Antonio, you have 30 minutes for your presentation. Thank you so very much, Jaime. Thank you so much for this invitation. And now I'm going to move to Portuguese because I'm going to give my presentation in Portuguese. Anyhow, now I'm going to be sharing my presentation in Spanish. Can you see it on screen, Jaime? Yeah, Antonio, we see it on screen. Thank you so much. And as was said in my introduction, I also work for a Verité that works on the implementation of different initiatives in Latin America and the Caribbean. Specifically, I am a program director in Brazil, and they have asked me to talk today a little bit about the context of human trafficking and forced labor, as we call it in Brazil, slave labor, and I'm going to address the difference between the two of them. And I would like to explain how we have that difference in Brazil. And I'm also going to present some data on the status of the problem in Brazil, the historical context, and discuss the different public policies implemented to cope with this kind of violations, trying to focus on the concept of dirty lists, which is a list of different employers that have been identified by subduing workers under slave conditions, and also try to cast some light on how we could make progress in order to prevent these violations. in Brazil and throughout the rest of the world. But before we start presenting the different cases, I would like to describe the profile of these cases in Brazil. And to do that, I wanted to discuss the Brazilian notion of slave analogous work. This is a notion that, when created in 2003, upon a change of criminal laws in Brazil, and Article 149 of the Brazilian Criminal Code introduces the idea, the notion of work analogous to slave labor or slave analogous work. Why did we decide to call it like that? In Brazil, we wanted to draw a distinction between the classical slavery that Brazil suffered, because as you know, Brazil was among the last countries in Latin America to abolish slavery. And despite that, we still have some situations that are very close to what could be considered slave labor. Therefore, Article 149 of the Criminal Code introduces this new notion of work analogous to slave work. In Brazil, public policy and the different initiatives dealing with this issue emerged with a strong focus on this notion of work analogous to slave work. At the same time, through a greater dissemination and awareness raising, it has now become called slave work. And when I'm talking about work analogous to slave work, informally for the purposes of this presentation, we are just going to call it slave work. And it is also important to note why in Brazil there are two very specific currents two approaches to address this type of violations. First and foremost, it is important to note that every discussion and creation of public policy in Brazil emerged in response to the different claims and reports recorded since 1970s for the exploitation of workers that throughout time was linked to Convention 29 of the ILO. It is important for everyone to know that in Brazil, the discussion in Brazil on labor exploitation commenced very early under the umbrella of the ILO forced labor concept and also associated to the area of human rights. And therefore, there was this whole approach in public policy making led by the topic of forced labor or slave labor, as we call it in Brazil. In some other countries in Latin America and Central America, they have sound laws to address forced labors in connection with human trafficking crimes. But in Brazil, that had to do with a much stronger focus on sexual exploitation. And it was because of that that only in 2016, when this work analogous to slave work was established in 2003, but it was not until 2016 that the concept of human trafficking for labor exploitation was introduced, although it had been discussed under the Protocol of Palermo. But as I said, it was not introduced to Brazilian laws until 2016. And that's the end of the system. And from then on, we're talking 6 years back, we started to approach that.
This discussion always occurs based on the perspective that the concept of human trafficking for labor exploitation and the concept of slave labor are very close, are very similar. They are very similar, they are in close contact, and they need to be visualized in a single way. Therefore, the public policies has been ready to deal with that similarity when the concept of human trafficking has become part of Article 19 of the Criminal Code. They are so close that one is part of the article of human trafficking. With that, I would like to express how this concept of slave labor is established in Brazil. And it is important to say that in the year 2003, that is to say, 21 years ago, this concept was set forth by amending the Criminal Code that draws 4 main components in order to make a classification of a type of exploitation like slave labor. The first one is forced labor. That is quite similar to the concept of the Convention 1929 of the ILO, that is any words exerted from an individual under threat or menace of punishment for which an individual was voluntarily offered. That is a formal concept. However, it also is also based on other concepts like comprehensive workday. That is to say that workday that goes beyond the number of legal hours and the very precarious working conditions, and does not give the person enough time for him or her to recover for the new working session. Therefore, we can see that that indicator is the same that was presented by my colleague when he talked about voluntary work. I mean, there we have the exhaustive work session, and that's not something random. Those indicators of forced labor that try to attempt to describe within the convention, and based on the ILO experience, upon observing all these situations in the world, of course, all these bore an influence in Brazil. Therefore, that concept fits into itself. And the indicators that we have of being voluntary were based upon the empiric evidence of those that are worked along these issues on the field. And also with the discussions of ILO scholars that work with these indicators that go beyond, for example, international case law, that the Inter-American Court of Law. I mean, so he made reference about degrading working conditions, and Quinn has also expressed that these are indicators that they also take into account, and then the limitation of movement due to debts, that is to say, debt bondage. And there are 2 aggravating factors in Brazil. It is also considered slave labor when, in addition to the restriction of movement, that happens because the employee cannot move, or he cannot move because he's subject to physical threats or even the withholding of documents. And in order to continue with my presentation, it's necessary to say that not all these components should appear concurrently so that labor can be considered labor, slave labor. Just with the occurrence of one of these items allows us to classify the situation as slave labor. With that, I would like to make reference to the profile or the description of those exploited workers, those that have been rescued since 1995 to date. Well, in fact, they are internal migrants, and a small percentage of foreigners, only 1.98% are foreigners among the ones that were rescued. And I mean, the number of individuals rescued is sort of the tip of the iceberg. They only are the ones that are above sea level. I mean, the tip of the iceberg, because under the tip of the iceberg, there's a huge structure, a very huge structure of workers that are not rescued, that are not reached out. There has been an assessment done, and we know that there is a large mass of workers who are subjected to these conditions in Brazil and that have not been rescued. But out of those rescued, we know that they fulfill this profile. A large number of internal migrants, some foreigners, mostly men. And then I will add something else to this gender issue. 60% of those workers are Black, and 65% of them are illiterate or have a very low education level. And this is also connected to child labor. I like working with all these matter related to child labor that also leads to slavery. There is an ILO paper of 2005 with rescued workers that showed that almost all the workers rescued at the time the paper was written had started working when they were about or around 11 years of age. Then those were workers that were subject to child labor. That's why it was difficult for them to continue going to school, finishing their studies. And that took the possibility away from them of being aware, being knowledgeable, being trained and qualified in some way in order to obtain better work opportunities. And that made them even more vulnerable and continued along this poverty circle. And that is one of the factors that made them vulnerable in order to be subjected to slavery. Of course, this is related to structural poverty and the structural inequality that we live in many Latin American countries and Central America. Of course, this also happens in Brazil and is a major factor. The vulnerability of workers shall not be considered the cause of slave labor, because the cause of slave labor is the attempt to profit easily by exploiting workers, paying very low salaries or wages, and depriving them of their rights. That's the cause of slave labor. Factors like vulnerability, illiteracy are just contributing factors that make workers more vulnerable to end up doing slave labor. It's important to mention this because many discussions believe that the worker is a pivot of his or her own whereabouts, as if the worker ended up being exploited because of his own sake. And it is important then, or it's worth highlighting that the main reason for labor exploitation is to raise easy profit or income. Well, let's focus now on the sectors that are involved with a higher number of slave labor. Well, the source of data comes from the initiatives to rescue workers. This is maintained by the prosecutor's office in Brazil. It's a very large database, and I suggest you're searching in Google in this data repository from the observatory, because it really contains very wealthy data about child labor, human trafficking, and slave labor from Brazil. These are the stakeholders involved. This data comes from 2002 to date. In 2002 is when they started mapping out the sectors involved in the slave labor. There's a predominance in livestock and sugarcane, forestry, coffee, manufacturing of alcohol, that is a byproduct of sugarcane, civil construction, and others. This is a source of migrants, or the origin of migrants when we talk about external migrants and foreigners. A bulk of workers come from Bolivia. Among those that were rescued, I'm talking about that group. Currently, there is a migration flow from Venezuela, and they end up being exploited somehow. However, in the history of all the situation, first comes Bolivia, then Haiti, Paraguay, Peru, China, and others. And I would like to clear up some things or clarify some points. By and large, agriculture, livestock, and civil construction have a large mass of internal migrants among the victims and a small percentage of immigrants. In the textile sector or garment sector, there is a mass of migrant workers coming from South America, Bolivia, Paraguay, Peru, and now from Venezuela. It's interesting to point out that when looking into China, you can see that there are many Chinese that are rescued from slave labor in the trade sector. In Rio de Janeiro, there was a large mass of Chinese workers that were rescued from slave labor performed in pastry stores. This is what I wanted to share with you to describe the different cases and the profile of slave workers in Brazil. But in order to dig deeper and talk about the dirty or blacklist, I would like to talk about the historical context. Well, how did we get there? Well, this started in the 70s when Brazil started to promote or to have promotion policies. That was during the military dictatorship, and the government started to promote the distribution of the population to cover all its geographical footprint. And then claims and complaints were made, and then we have the land commission by the Catholic sector that may report about slavery and the logging of native forests for the agricultural development, moreover for livestock. This happened between the 70s and the 90s, first in Brazil, then in the international communities, including in the ILO and the Inter-American Human Rights Commission. And this is very important. I want to highlight all this because much of the evolution or much of the way in which public policies evolved came about from civil society. Therefore, we need to know that there are civil society organizations, and there need to be civil society organizations acting upon these topics, these issues, because it is very important to promote public policies that serve the needs of workers, both female and male workers, that suffer from exploitation, as it was expressed by Yesenia during her presentation, who was able to portray workers that still live under those circumstances in Brazil, in Latin America, and in the rest of the world. Therefore, between 1970 and 1990, even during the dictatorship in Brazil, that came to an end by mid-90s, and then was followed by the first democratic government that had certain quite unclear initiatives. Up until in the 90s, the government appropriated that topic or got hold of that topic and developed important public policies. Many complaints were filed by civil society organizations, and in 1995, Brazil officially recognized that slave labor is what's present in its land. Then a special group of prosecutors was created who would oversee slave labor, and some public policies were developed that little by little would start looking into this topic between 1995 and the year 2003. And let's make a pause there, because there is a landmark there. 11,152 workers were rescued from slave labor by these special groups of prosecutors that were overseeing the situation. Therefore, a large mass of workers came into sight. In 2003, there was another landmark in Brazil. As I've said before, the concept of situations similar to slavery was established in 2003 by law. The National Commission for the Eradication of Slave Work was created, that clusters government organizations, civil society organizations, workers associations, employees associations, the Brazilian justice system, the labor justice system. Not every country has something like this. In Brazil, there is labor justice. There is a labor justice system. Then at that time, the CONATRAE, as its acronym goes, was created, and the first national plan for the eradication of slave labor was established. And it's very important to understand that at that time, the dirty list or black list was created. What do we mean by black or dirty list? Well, it is the name given to the registry of employers who have subjected their workers to slavery-like conditions. It's sort of a nickname, or an acronym, this dirty list. It was passed by a resolution that is sort of below the level or legal status of a law. And this dirty list or blacklist makes the number of the name of the companies that exploit workers visible or transparent to everybody. No punishment is provided for by this dirty or blacklist. However, there were consequences. First, everybody knows, and this is very broadly disseminated, everyone ends up knowing about them. And civil society here plays a huge role because it disseminates the list, makes analysis of the list, it takes into account the sectors involved, stories or anecdotes are related. Then back in 2009, a law was enacted that prohibits a granting of loans and funding by the National Development Bank for those companies using slave labor. And the Brazilian central bank prohibits private and public banks to fund those that are part of the dirty list. And this occurred in 2010. And though it is an instrument that does not provide for punishment or penalty, it has been used by many institutions as a way of punishing or preventing slave labor in Brazil.
And now there are several national and international companies that are consulting this list before purchasing Brazilian commodities, whether in the domestic or in the foreign market. But not everything is positive, and we still face many challenges. The prohibition to the banks not to finance the dirty list does not always work. There are studies that were conducted a couple of years ago saying that it does not work in practice. And there are frequent attacks on the part of governments, as it was the case after the coup against President Dilma, and also attacks against the dirty list, and also several private actors. There have been several private stakeholders that had actually challenged the constitutionality of the dirty list before the judiciary, but that those requests have been denied. And case law is uniform in that regard. And despite all this progress, Brazil still sees a very high number of workers that are being rescued from slave work. That means that there's a public policy structure for oversight, autonomous oversight, labor courts, civil courts, and there are several fines to those found guilty of exploitation. There is the dirty list, and there is unemployment insurance. And despite all of that, more and more workers are rescued from this kind of labor. And of course, it has to do with the capacity of the government of conducting these oversight activities. But we have also noticed the problem despite progress made over the last 20 years. So some just final considerations. We would like to see how to continue making progress to eradicate this, particularly considering that my empirical evaluation after the 20 years I've been working on the field. Today, I think it is extremely important to have repressive public policies, but we need to go far beyond that. We need to keep on working on prevention of human trafficking, prevention of forced labor, and how do we effectively move forward towards the eradication of slave work in Brazil. And as part of that final reflection, we must say that the government is currently in the process of designing national human rights policies that seeks to promote a closer collaboration between the productive sector and public policies in order to keep on working on the private sector in Brazil. For the private sector, the key point is to implement effective supply chain monitoring systems and due diligence procedures. Finally, for workers, in Brazil, there is a problem in relation to workers because the 2017 labor reform resulted in weakened union associations and organizations. So it is important to enhance the capacity for dialogue with the private sector on human rights due diligence. Because this is a requirement that has been more and more embraced among several commodity importers that want to guarantee that their supply chains are free of violations and sustainable. And in terms of the civil society, we need to keep on producing knowledge, mobilizing society, and support the creation of innovative tools while exerting pressures on policy makers to have an ever-growing presence, not only in terms of repression, but also prevention and assistance to victims. That's all I wanted to present. Thank you very much. There's my email address, and feel free to reach out to me if you want any further information. Thank you so much, Antonio, for such a thorough presentation. We're going to move on to the Q&A. The truth is that it has been a very rich panel. Thank you, thanks to all of our speakers. We've received so many questions, it will not be possible to answer them all. So we're going to ask one question to every one of our speakers, and we ask them not to take more than 2 minutes in responding them. First, to Queen Kepes. In the experience of your organization, what have been the industries and companies that have gained the greatest awareness and have assumed the greatest commitment to prevent human trafficking? Tough question. Because of conflicts of interest, I cannot go into so many details as to the specific companies and firms. But in terms of industries, well, it varies a lot. We've put a lot of effort on the coffee sector and the coffee field through the Proyecto Coffee project led by Antonio in order to fight forced labor and child labor. And we've had very good responses on the part of different companies that have funded supplementary investigations and have committed to work on supply chains in order to promote different actions to identify and address cases of forced labor. Specifically, I could point out Dr. Pepper, which is a company that has funded different research both into child labor and forced labor in countries such as Guatemala, Colombia, Mexico, and Brazil. As well as a study on worthy salaries and worthy living working conditions in the coffee industry in Colombia, and that have been worked side by side with us in addressing these problems. And we've also worked on this with other companies with whom we've had strategic partnerships, such as Philip Morris International. And generally speaking, with the new due diligence regulations on human rights, in addition to the prohibition of imports of products produced through the violation of human rights, many companies have been taken for labor and human rights violations much more seriously when it comes to their supply chain. And we hope it's gonna be better. So Queens, it is undoubtedly extremely important for private companies to be involved in this fight as well. And Yesenia, you received from the authorities of Chile the support so that these people will pay for the crimes they committed against you. Well, Jaime, thank you very much for your question. And no, the answer is no, not for us. And I say us because it's actually a very large group. We are several people that tried to file a labor complaint at one point because there were a lot of people that knew it. We won that labor claim, but we were never compensated for that. That was back in 2019. And after that, thanks to the Libera Foundation that reached out to us, we are in the process of filing a criminal complaint to gain some justice. But we've been trying to do this criminal proceeding for years. We've even filed international claims because in Chile, we have several international treaties and instruments prohibiting human trafficking and forced labor. But we have not had justice so far. There has been no trial. We are still waiting for the investigations to be completed because it's been years and we've had no response so far. And another important issue is that if people do not see that justice can be made, how will they see that it's useful to file a complaint? If there's no justice made in a case so huge, involving so many people, where so much evidence has been gathered, involving people in positions of powers that made victims out of us, that trafficked us, that turned us into slaves, and yet we've seen no justice. So those that are victims right now, how would they believe that there's a point in filing a complaint? We want justice, and that is why we are requesting everyone in a position of power and that are looking at this training, that are attending this training. We ask them to honor their work, to honor their profession, and to do the right thing. We still await justice, and we can only hope that justice will be done. Thank you very much, Yesenia, for your response. It is true that we need justice. And in connection, well, along the same lines, Antonio, the next question goes out to you. And it also refers to a judgment. I don't know what the impact has been of the Hacienda Verde against Brazil case in this fight against slave labor. It has had a very strong impact. Yeah, this Hacienda Verde and the Pereira workers were actually leading cases that were brought to the Inter-American Court of Human Rights. And the Hacienda Verde case was a case that took very long before Brazil would actually begin to offer the victims, the survivors, some sort of a justice, as Yesenia was saying. And sometimes compensation is required, if we can talk about that, because actually remediation is not possible because the damage cost will no longer be cured. However, the Hacienda Verde was extremely important because it shook public policy makers. It strengthened the need for the government, for the state of Brazil, to start focusing on these problems. And it was a huge contribution for the progress in Brazilian public laws. And that is the civil society that needs to be thanked for that, because they played a key role in advocating for that case to move forward and for Brazil to be convicted. And that was a milestone in the evolution of Brazilian public policies. And I often highlight the importance of civil society when it comes to surveillance on these issues, but also the dialogue with the government and with the private sector in the production of knowledge to keep on moving forward in the fight against these type of violations, which are the worst type of human rights violations that can take place in the labor environment. Thank you very much, Antonio, for your response. And with that, we would like to conclude this panel. Thank you very much to our three speakers. And right now we are going to take a break and we're going to be back at 11:15 for our next panel. Thank you very much.
Dear participants, good morning, good afternoon, and good evening, depending on the time zone from where you're watching us. My name is Marcia Guerra Capanema, and I will be moderating this panel of the International Course on Human Rights. I'm the Executive Director of the Rivera Foundation, an organization that works against trafficking and forced labor. That's why it is a pleasure for me to participate in this seminar and listen to this panel that I believe will be reinforcing everything we have done so far. We'd like to remind you that we have interpretation services. Therefore, the participants will have to choose the language of choice. We would like to ask the speakers to speak slowly so as to make the translation feasible. In addition to that, we would like to tell you that in order to guarantee accessibility of this international human rights course, we have interpretation of sign language. During all the transmission, the interpreters will be present together with the speakers, letting all the participants to have full access to the content presented. We hope you've been able to enjoy the panel entitled Forms of Labor Exploitation in Africa, Latin America, and the Caribbean. Those who have been unable to watch it, please remember that you can find its recording on the platform in the section Previous Classes. This panel entitled Due Diligence and Undue Diligence, the Role of the Business Community. We are joined by Fernanda Hoppenheim, Jose Julian Tolle, and Felipe Enriquez. The panel will address a discussion about companies and human rights. The category of due diligence has become a principle for consensus to promote good practices and encourage a fruitful dialogue among businessmen, trade unions, civil society, and the states. We will listen to the perspectives and opinions of the main international agencies that advocate those advances and also the critical outlook of the civil society organization representatives. To start with, I would like to give the floor to Fernanda Hoppenheim Cabrera, who's the president of the UN work team on companies and human rights, and she's a coordinator of the project about organization development, education, and research. PODER, as its acronym goes. You can read her complete bio on our platform. Fernanda, you have 25 minutes for your presentation. Please, you have the floor. Thank you, Marcia, and I would like to thank all the organizers of this course that is so important. And of course, I would like to thank all the participants. It is a pleasure to be in the morning of Mexico or afternoon or evening from wherever you are watching us. I would like to share my presentation. I hope you can see it correctly. First, I would like to start with by connecting these two items on the agenda, human rights and companies. That is from where the concept of due diligence in human rights arises, moreover as connected to business ventures and the company's supply chains. First, I would like to talk about the main international standards that guide or govern the discussion and the implementation of the protections for human rights within the framework of the business community currently. On the one hand, we have the OECD, the guidelines for multinational enterprises on responsible business conduct that were adopted in 1976 for the first time and are not only applicable in the OECD country members, but also to all the states that have underwritten the declaration that gave way or gave rise to these guidelines. It was reviewed in 2023 and new general guidelines were included for responsible business conduct, but also highlights several important issues, environmental issues and climate change related topics, gender issues, the protection for human rights defenders, and there's emphasis placed on the right holders who are potential victims of human rights abuses. Then these guidelines are part of what guides this discussion. They include a human rights language, and the OECD has, in addition to these guidelines, other guidelines and regulations that set forth different steps and provide recommendations for the implementation of this due diligence process in human rights that we will be describing in brief. On the other hand, the ILO, of course, has 190 conventions that are binding when ratified by the states that cover different topics, different issues within the labor human rights agenda, among other topics. However, as regards companies and human rights, the Tripartite Declaration of Principles concerning multinational enterprises and social policy that was enacted in 1977 and updated in 2022 makes up the key source for the work of the ILO in this matter. And finally, and this is the main guideline for our work group, we have the guiding principles on business and human rights, which were adopted in 2011 in the Human Rights Council, and that are the international standard that is broadly recognized in terms of human rights and companies. These guiding principles are organized or have been developed within the framework of the framework that we call Protect, Respect, and Remediate. And it's based upon 3 pillars that gather the 31 principles of labor and human rights of the UN. The first pillar, protecting, is based on the duty of the state to protect human rights, specifically against abuses by private actors, including companies. That is, the guiding principles organize the obligations that the states have, that already exist. States are mandated to protect their human rights. However, they organize these duties around the activities performed by the private sector. Then, guidelines, specific guidelines are designed for states to fulfill with their duty of protection. Then the guiding principles talk about the fact that states need to lead by example. It means that states, not only as guarantors of human rights, shall guarantee that they are not violating human rights themselves and guarantee that companies do not abuse or damage or hamper human rights, but rather within their economic activities, they have to be a role model or to lead by example. The activities that we refer to are the state-owned companies or companies in which a state has a share, or the mixed capital initiatives, the private-public ventures where the state has an important weight or an important share, investment projects, for example, in the processes of public hiring or any exchange that the private sector has with the public sector. For example, export incentives or credits, that it's also a link between the public and private sector. Therefore, all those economic activities the state is involved, it shall guarantee human rights, it shall guarantee the fulfillment of human rights, and prevention should take place in these activities so that the state shall be the one that leads by example and sets clear expectations for the private sector. As regards the implementation, there are many examples, as I said before. In the last 13 years since the adoption of the guiding principles, several countries, more than 30, have put into place national action plans of companies and human rights, or have put into practice policies to guarantee these rights in the state public policy. Laws have been passed and regulations set forth, including due diligence in human rights, and then we will be focusing on that. The second pillar. Can you get closer to the mic, please? Yeah, it's better now. Thank you. The second pillar is focused on the responsibility of companies to respect human rights. The state is obliged to protect and guarantee that companies are mandated to respect human rights in all their operations and value chains. This is no minor issue, because it's not only towards the workers or operations on main business operations where they subject direct control, but rather in their commercial relations and the value chain, and supply chain with the providers and suppliers. Therefore, companies shall refrain from harming human rights and should pursue initiatives to identify the risks to human rights or the potential damages or negative or adverse impacts they may cause, apply prevention and mitigation measures to mitigate those potential risks, and when they do happen, have reparation mechanisms, appropriate reparation mechanisms. This applies to every company. The responsibility to respect human rights applies to all companies of every size. As there are different states, small states with less than 1 million inhabitants, to federal states with hundreds of millions of inhabitants, in some cases more than 1 billion inhabitants, they have all of them, they have the same obligations to guarantee human rights. Then companies are also liable regardless of how diverse the private sector might be. Of course, it is different when talking about multinational companies running or operating in several countries and several jurisdictions with global supply chains and complex situations, and with many more resources to pursue these processes and to make these commitments with human rights and to put into practice this concrete plan than an SME, a local SME located in a country, or the bakers on the corner of our neighborhood. Therefore, seeing to that diversity, things can be different, but every company is responsible for fulfilling with the respect of human rights. This can be implemented, put into practice in different ways. First, the companies need to have public commitments with human rights. Another way is, that is at the heart of today's discussion, is they can implement due diligence in human rights. And the third pillar, that is guaranteeing remediation or reparation, and that this mechanism shall be accessible when damage does occur. Therefore, victims, or the victims, whether they are individuals or communities, for example, an indigenous community or a group of persons, they shall have access to these effective and appropriate mechanisms. Then some mechanisms will be state mechanisms that will resort to the justice system, so they would access that reparation, remediation by way of the justice system through sentences on decisions that compel the state and the companies to repair. There might be state-provided mechanisms, but are extrajudicial mechanisms. They are not part of these litigation processes of accessing justice through legal proceedings. That might be, for example, ombudsperson's offices or national human rights institutions, public defenders' offices that might make recommendations and in some cases mediations, or in order to facilitate the access to those remedies. Some other offices like the national contact point, and that would be my colleague who will be addressing that topic. These offices that sort of stem from the guidance of the OECD, and these offices might make recommendations, stand up as mediators and seek solutions. And for sure, the company-based mechanisms that are not state-based, but are like maybe toll-free numbers, complaints, or lines that not only receive those complaints or reports, but are responsible for providing solutions, those reparations that need to occur when human rights have been damaged. Some key messages of these guidelines. On the one hand, it is important to highlight that they do not set forth new obligations and responsibilities neither for states nor for companies. It means that states are already liable or responsible for protecting human rights, and this has been adopted by constitutions or international treaties ratified by our states that protect our rights. Therefore, there are not new obligations, but those obligations are organized by guiding principles in order to make clear what they mean in the face of the business activity.
Furthermore, all natural legal persons, including companies or private parties, we could say the responsibility not to infringe upon anyone else's human rights. This is not a new responsibility, but it is clearly set forth for companies, and there are also clear guidelines on how that responsibility should be fulfilled. They cover all internationally recognized rights, and it's extremely important that when it is recognized universally, for a new right, as it was the case in 2022, the United Nations recognized the right to a clean and pure environment that is immediately covered by these guiding principles, and it needs to be embedded in these due diligence prevention processes. And the basic principle is to do no harm, and the risk assessment carried out in this human rights due diligence process needs to be carried out with people and the environment at the center. It is also important to have effective remediation mechanisms and to have adequate remediation may take different forms in different cases, but victims need to be involved in that process every single time so that they are involved in the decision making as to the remediation that they need. The purpose of the guide principles is to prevent violations of human rights through business activities, basically to promote human rights of most vulnerable groups. Now, addressing a corporate responsibility specifically, clear this responsibility to respect. Companies have a standalone responsibility. Standalone is highlighted for a reason, to respect human rights to everyone of their operations and value chains. Many such abuses take place in value chain, sometimes in the core activities of the company, but in other cases, they take place, for instance, during transportation or during the production, for instance, in the textile industry, they take place in the shops where large brands, large labels produce their companies, or in the fields where wheat is being collected for large companies that processes and sells products such as cookies, crackers, or bread, just to name a few. And that is why corporate responsibility throughout the value chain is particularly important. and it's independent from the state's will or capacity to protect human rights. And this is paramount, because if the state has, for instance, insufficient legal protections or they are embarked on any regressive human rights protection policies that will not relieve companies their responsibility. If the state has a sound legal framework for the protection of human rights, but yet lacks the capacity to implement such framework or for monitoring, inspection, and enforcement, that will not relieve companies of fulfilling their responsibility to protect human rights. Therefore, due diligence becomes an extremely useful tool to hold companies accountable to respect human rights, to adopt this preventive approach, and to do no harm. I'd like to highlight that this is independent or standalone because we've seen a trend over the last few years to regulate due diligence by multiple states to turn it into a mandatory requirement. And it's extremely important because the mandatory nature is key for companies to be forced to comply with these principles. But when there are no such laws or when there are the process of being developed, companies still need to conduct this due diligence. The source of due diligence are the guiding principles, as I said earlier, and specifically in Principle 17, remember that there are 31 principles, but Principle 17 states that with the purpose of identifying, preventing, mitigating, and responding for the negative impact of acceptable human rights, companies need to conduct due diligence. And this is extremely important, and it said it needs to include impact assessment, both including assessment of the potential impact of their activities. They need to interpret the conclusions and act accordingly. That is, deploy the prevention mitigation measures and monitor responses and communicate effectively. This principle collects every single element, and then they're broken down into other elements. And as I said earlier, there are OECD guidelines, there are guidelines of the High Commissioner for Latin America in the concept of Lateral Project for Responsible Conduct in Latin America and the Caribbean. That I am part of the team that works on the development of guidelines that I can share with you later. The companies need to identify and assess these negative impacts, and these processes need to include substantial consultations with the groups potentially affected thereby. At the principles of the way through 21 on due diligence, and need to integrate these conclusions in the operation. They must take time measures, they must follow up on the effectiveness of their response, and indicate the measure that they have adopted to the work. That is, they need to communicate those measures, particularly to those affected or their representatives. Now, what does it mean to implement due diligence? First of all, it refers to the implementation of preliminary studies for impact assessment. And I understand that Professor Toll described what due diligence is not in order to draw distinction. This preliminary work are nothing but a risk assessment exercise. And I would say that companies conduct risk assessment for many things before they invest in a country or in a project. They conduct risk assessment before they launch the market, business risk assessment, marketing, competitors, financial risk, exposure, and many more. This is another risk assessment being human rights. So the approach then changes because it's necessarily a risk to the company, or at least that's something, because of course that could result in identifying risk to the company as such. But in this case, we're assessing the risk to people, to environment, to communities. So there's a shift in approach. Human rights are individual, intertwined, and instrumental. When one right is impaired, that will trigger the impairment of many other rights. That having been said, companies don't get to choose. However, there are certain industries or certain contexts, certain geographies where some rights are more at rest. For instance, if you operate in an area that is affected by armed conflict, there are risks to life, for instance, differently from case if you operate at a financial institution located in the city. So prioritizing the separate on which due diligence will focus is extremely important in order to identify the most salient risks. That's what we call them, the most prominent risks, or those that are more likely to materialize or materialize more often. That's including environmental rights, right to water, education, labor rights, cultural rights. And of course, in the topic and their analysis includes guaranteeing that there is no human fighting, human trafficking, no modern slavery, no forced labor anywhere through their operations or their supply and chains or chains. These assessments must be conducted by an independent expert team. We do not recommend that the company do it alone, because we do need those external eyes on us, and we must encourage the involvement of all stakeholders, particularly those right holders and the community especially affected. Additionally, we need to analyze the outcomes of these studies in order to define those prevention mitigation measures. Remember that the principles speak about these outcomes informing the evaluation and incorporation to be done through the measures, and measures need to be very clear and specific, very targeted. And we always recommend to hold a predictive process in order to share these results with those really affected or actually affected and other stakeholders, so that they can also inform these mitigation and prevention plans. We need to allow adequate time in order for these concerns to be voiced and to receive additional proposals so that these measures can be adequately informed. We also need to develop and incorporate indicators and follow-up mechanisms, and these need to be clear and effective. Their effectiveness and efficacy must be measured throughout time. Therefore, once the risks have been identified, we need to deploy the most adequate mitigation and remediation measures. We create indicators to measure the efficacy of those measures and to determine whether these measures effectively worked. And we need to create mechanisms to follow up on those measures through supervision, oversight, monitoring. All of those steps are part of the due diligence process. The communication of these outcomes and dissemination of these agreements, the communication plan is also necessary in order for the outside world to gain a better understanding. And we're not only talking about the people affected, but also investors, anyone that has interest in the company, because it's going to be very important for them to have access to these outcomes. And at the end of the process, we need to revisit the procedures. For instance, the EU guideline approved in June this year, which is mandatory for the 27 members of the EU, applies to the largest European companies. Their supply chains as well, and for them to conduct this due diligence process is one of the regulatory developments that make the due diligence mandatory, and this implies that they need to be reviewed every year. Frequency is very important. It's not a once-off effort. First impact may evolve throughout time because they're dynamic. And I must also say that among these prevention mitigation mechanisms, and as part of the due diligence process, we also need to include the development of an operational mechanism in order for remediation. As I said at the very beginning of this presentation, it is very important to guarantee access to remediation compensation for victims once damage has, when harm has been inflicted. This cannot be an ad hoc mechanism. It needs to be readily available and be triggered once the due diligence process is completed. How can due diligence be useful in preventing human trafficking and human exploitation? I'm about to close. On the one hand, through commitment by the companies, zero tolerance and a strong commitment to fight against human trafficking and make sure that it does not occur during their operations. This is important. It's the first step to diligence, as I was saying earlier, improve a useful procedure in order to identify all that trust for human trafficking throughout the value chain, throughout their operations, in order to adopt the necessary prevention measures. I've seen lately that some airlines are posting some cards indicating what are the different signs to identify potential human trafficking victims or people being transported by air against their will and trying to get the passengers involved in raise these red flags. This is the measure that could have arisen out of the diligence process. And through these proceedings, companies can adopt different measures in this regard. Strict regulations on human trafficking and modern slavery, demanding companies to prove that there are no such violations of human rights in their places. There are countries that have already made it rather explicitly, like the UK, Canada, Australia, just to name a few. There are two key approaches, and let me wrap up with this, which is the value chain approach that is not thinking solely of the original companies. Like human trafficking is not possible here because migrations are quite limited and they're restricted to an area that is not at risk. But this company also is from others, and it may be a risk of human trafficking across the value chain. And also the differentiated approach. That approach, understanding the potential impact on women, for instance, but also a cross-sectional approach, including populations at risk, for instance, migrants, asylum seekers, LGBTQI, racial communities, indigenous communities, African descendant communities in our region, children and youth. Therefore, that differential approach is key in order to understand this specific risk of them. And to have this sectoral approach, both sectors are more at risk for human trafficking, exploitation, and slaving dynamics. Thank you very much. And I'm going to be here to answer any questions you may have. Thank you so much, Fernanda. Your presentation was extremely interesting and educational. right now, we are going to give the floor to Jose Julian Tolle, Human Rights and Businesses of the Externado University in Colombia. Julian, go ahead, person Fernanda and her work team, and to take a deeper dive into some of the issues from two different angles. On the one hand, based on my academic experience in research, because we are the Latin American Observatory have supported civil society in the negotiation of the binding agreement in Geneva. But this year, we also completed the first initiative, the first legislative initiative for a framework of due diligence for human rights in Colombia. This initiative was developed, led by the Office of the Ombudsperson in Colombia. So, as I said, two different angles, the technical academic perspective, but I would also like to see this opportunity to highlight another element that has proven extremely useful in understanding the difficulties and challenges of human rights due diligence, that has to do with the second due diligence process that I support by one of the largest gas companies in Colombia. So I would like to articulate these two experiences in order to speak a little bit about what due diligence is and what it is not. I will now share my screen. Please let me know if it's working correctly. Yep, that's on. So I would like to start with the first element, which is, what is this notion, this concept that seems rather clear, or there seems to be a consensus based on universal standards, and it has been actually set out in Principle 17 of the Guiding Principles. So this has in turn been turned into a series of guidelines, such as the OECD guidelines, but also certain think tanks, such as the work on the part of the Danish Institute. So there are several approaches that have developed the notion.
This is not a new concept or notion, neither for the companies, nor for human rights, and let alone it's a concept that has not been a part of international law or regulations. This concept has been originated remotely. I mean, it may come from Roman law, where they talked about the due diligence of the good father. And from that time on, there has been, or this concept has been broadened or has been used at different times and in different areas in the context of social relations. For example, in corporate law or commercial law, this is a very common concept. Moreover, as to what pertains the representative or the company's manager, administrator, though more recently it has also been used in international human rights international law, we speak of due diligence and the state obligation as regards gender-based violence. Therefore, the only new thing about this concept is that has been used, or it has become a tool to make two sectors talk or communicate, two sectors that apparently were two different edges. First, how business should be done, what is the limit to a business decision, and on the other hand, who should fulfill obligations in terms of human rights. I must tell you that this is one of the most complex paradigms of the regulations applicable to companies and human rights, because historically, for Western culture, we have like two sides, public law and private law. And international law follows that dynamic of public international law made up of international human rights, international humanitarian law, international criminal law. And on the other side, you have international rights of foreign investments, business, trade, and apparently that idea of harmonizing or putting together has been quite difficult. And there comes due diligence as a tool that helps to bring up this dialogue. However, Fernanda has already been defining this notion or concept, and these minutes I have left, I would like to tell you what this means in the reality of human rights and companies, moreover, within the Latin American framework. How shall we think or rethink this? Because due diligence has already been enforced or applied under a national set of rules or laws, and in the case of Europe, under community-based laws, where it's no longer a voluntary tool but a mandatory tool. But what does this imply for Latin America? How can we put it into practice? Attempts have already been made by the OECD and some other institutions to provide guidelines, notions, ideas, and try to bring about some practice. However, Julian? Julian, there have been some interruptions and we can't hear you. I would like to ask our audience for a couple of minutes because we will be contacting our speaker. We thank you for your patience, and Julian will join back in a minute. Thank you so much. Our speaker, Julian, is being reconnected. Let's wait for a couple of minutes. The speaker has told us that he will be connecting in a couple of minutes. I mean, there was a blackout where he is. I can see him. I'm sorry. This is one of the problems in the South. No problem. If you want to share screen again, please. Well, I'm sorry. This is one of the problems affecting Latin America and the South. Power supply, it's not guaranteed as a basic service of utility. Well, resuming with our topic, I was pointing out that we need to rethink these elements included in the definition or the notion of due diligence in human rights. This is one of the main challenges to see whether we can make this tool the bridge or that would help the dialogue between international human rights and the corporate or commercial rights of businesses. If this connection can be made, and in my opinion, and as Fernanda has said, the most important thing is to understand the aim, the spirit behind due diligence in human rights, that is to put at the heart of businesses, of a business decision, human rights, whether affecting an individual, a group of persons, or the environment. How to do it? Where there are some elements, and that's the aim of due diligence. How to do it? What control instruments are there are available? And I will start with the purpose of this discussion, that is to understand what is not due diligence. By stating what it is not, it might be better or easier for you to understand this tool. The first element that does not represent due diligence is that it does not expire in a single moment. In fact, due diligence is a process that relates different moments or stages. It does not come to an end in a single point or stage. Therefore, this process needs to take into consideration the steps stated in the guiding principles. We need to identify, to manage, to monitor, follow up, and communicate. And there's one that I want to mention at the end of this presentation that is called accountability or reparation. And there's a whole discussion as to what that last stage is like. Then this was also pointed out by Fernanda. What is the aim or the purpose? Is not, or it does not want to repair or make the companies accountable or responsible. And this is one of the elements that raises more confusion to human rights defenders or advocates and to companies themselves. The aim is essentially to prevent, to foresee, to anticipate to the actions of the companies that companies may undertake that might affect individual, collective, or rights of individuals on the environment. Due diligence cannot disregard proportionality. That is, we'll see that the steps or measures, prevention measures taken, or the measures taken so as to mitigate or suppress potential effect on human rights should be appropriate or adequate to the impact they might make, either because of the seriousness of the action or the likelihood that that action might lead to an effect on human rights. Another important aspect is that due diligence shall not be construed as a prevention exercise thinking of every effect, and that was also mentioned by Fernanda in connection with the guiding principles. The companies shall set priorities and therefore need to consider how they would prioritize the way in which effects will be made. I mean, which of these actions is more serious, and then start identifying from the top priority to the least priority the ones that the company will see to. Another important element of due diligence is that it's not rigid or static. Due diligence is a dynamic process, is a living process, because human rights and the relationship with business activities are changing by nature. Therefore, the applications of due diligence shall be permanently assessed and adjusted based on the situation that prevails in the territory and what is occurring or how this is impacting on the rights. Another key process is that this is not a widespread process. It does not apply to all the company. Due diligence needs to focus on each of the company's operations. That's why we can't think of comprehensive integral processes, but rather specific processes, because the company's operation in the south of Peru is not the same that the company's operation, the very same company's operation in the south of Colombia, because contexts change. Thus, this process needs to accommodate to the sector, to the size of the business, and the business itself. The business activity itself, as has already been mentioned by Fernanda. Another key element is that due diligence does not only see to the relations or consequences within the company's operation, but rather it should provide for the supply chain and the value chain, and that's something important to take into account. With this, as I would like to show you how these steps, these different stages, fulfill its aim, proportionality, the aim shall be taken into account at all times. An important element that for many is not part of due diligence, but is sort of the prior stage to this process, is the commitment of the company for human rights respect. This is a more subjective element, an element that is more connected to corporate policies and is connected to each one of the areas and each one of the individuals involved in the decision-making process of the company, or who are entitled to making decisions in a territory. Then we understand that we need to identify, assess, follow up, monitor, communicate, provide accountability, and repair. What is each of these steps like? And then we'll see whether we can provide it a different view or rethink it from Latin America. Commitment. What do we mean by company's commitment? As regards due diligence and in general is respecting and respect of human rights. For many companies, many companies are addressing this notion based on their reputation or from the point of view of presenting a human rights policy and bringing into their sustainability or corporate strategies. I will not judge whether this is good or bad, but this is a first step. And it all depends how they fulfill with this human rights policy or public statement. This might be positive or rather become a dissuasive element or distracting element. However, if we are talking about expressing an institutional commitment based on human rights within the framework of Latin America, well, following the OECD recommendations and in the light of the Inter-American system, I would like to tell you what it means making a commitment, because the Inter-American sector has made several recommendations. And they have issued some reports in 2019 and made great efforts to try to show how to make these statements in favor of human rights or promoting human rights. Something important needs to be taken into account, that this commitment shall be made at the highest and top level. It's very difficult to speak of due diligence when those that make decisions in boards of directors or general shareholders or special shareholders as meetings, or the president or area directors don't understand what it means or what the difference is between a sustainability policy or fulfillment policy and what we mean by respecting human rights. Therefore, the important thing here is first, not only to convince the top management, but rather to articulate it and to effect changes or let them get hold of these instruments so that they can align with this new commitment. That is why it is extremely important to set a list of priorities as to the topics related to the company based on human rights and with involvement of the different stakeholders. This is key because most of the policies put into practice by the company are done internally within their offices or communications areas. In order to have a human rights approach, first we need to ask the director what he means or what he understands by human rights and the way in which they consider the implementation of rights in the company. That's why these directors that are part of business decisions are key. It is also very important to deliver training so that from the operator, the one that is operating the machine, let's think of the security staff, let's think of, depending on the industry, whether it is mining, sort of the lower rank miner up until the top management, they are convinced based on knowledge.
So we need an educational awareness raising work in order to understand why human rights is a responsibility. In order to do that, we need to understand their essence, why a human right is binding upon the company, because most of them associate that to legal topics, and this goes far beyond that. The second of them has to do with identifying and evaluating. How do we conduct this identification and assessment exercise? I'm going to go a little bit faster because I know I'm running out of time. In this and in the other, I dwelled a little bit more, and now we're going to move a little bit faster. Identifying and evaluating is key in a due diligence process. What should I identify? And Fernanda had told us risks or potential adverse effect on human rights. But in order to be able to understand that, the first thing a company needs to do is to understand that these are not the company's risks. It's a company to the right holders, the company, the risks to the environment, the risks to humans and the environment. And this is tough because clearly characterizing and understanding who's the beneficiary will force me to have a human rights lens, a cross-sectional approach, a dialogue or a multicultural approach, differential approach, a territorial approach. And this is where the true due diligence exercise lies, because it is based on that in the identification that we will conduct an assessment. The problem with the assessment is that nowadays it's extremely hard to understand how to assess prevention or how to determine whether a right has been impaired. There are some guidelines that speak about degree of impairment or probability, but this needs to be rethought in Latin America because clearly this assessment will allow me to prioritize different rights for the company to select certain measures to drive change. Therefore, this assessment needs to be integrated in the company as a whole because this is not specific to an area. Human rights issue affects every single area. A labor issue may involve actually procurement or supply or the legal area, management, etc., etc. But this means that here, throughout this identification and assessment phase, we need to rethink that, customizing it to our context. Let me move to the third, and the others I'm going to move far more quickly. How do I manage these impacts and these impairments? The idea is to have due diligence action plans. These action plans, as I said earlier, need to be proportional, adequate, prioritized. But in addition to all these technical requirements, their ultimate purpose is how to prevent, how to stop, and exceptionally, how I mitigate. And in order to get there, the first thing I need to understand as a company is that the responsibility for the respect of human rights must bear in mind that it is a responsibility against control and direct impairment. That is when the company is the one that makes the decision. The second, it may be contributory. That is, the cause for that damage or harm is beyond the company's control, but the company still acts as a facilitator. And the third one, and even hardest, is the responsibility out of a contractual relationship or a business relationship. And as I said, this is the toughest because it's the one that has to do with value chains. But as I said earlier, and I'm almost over, let me say that the possibility of creating an action plan implies incorporating this assessment, this identification, accompanied by human rights focused measures. But all other measures should reflect the attempts by the company based on the resources available to them, because all companies in our countries will actually argue that they don't have resources. They have resources for damage compensation or for social work, but they may not have it for that. So how do I strike that balance between the resources available to the company and every one of the measures that they need to adopt? And then we're going to be looking at the financial indicators, the time indicators, the measure effectiveness indicators when it comes to providing compensation for these rights. Another element that is also key is follow-up and monitoring. Who's going to do it? And Fernanda provided some information on this. Of course, it needs to be an independent third party, and it needs to be a human rights expert. There needs to be oversight authority, and there may be certain mechanisms involving CSOs, NGOs, human rights associations, etc. And the last stage is how do I communicate that? I need to communicate this due diligence process. As Fernanda was saying, one of the guiding principles is to carry out this kind of integrated consultation involving these stakeholders. And finally, there's the issue of compensating and doing remedial work. We here in the south of Latin America, we have carefully examined whether due diligence should provide for remediation mechanisms and how they should be defined for several reasons, because due diligence may not seek to repair or mitigate it. It's basically preventive. When a company creates damage, that would be pillar 3, and there should be other mechanisms that are thought for mitigation or remediation. That is why all we say is that the reporting mechanisms should be the entry door in order for the company to identify whether they're related to prevention. Because if it is mitigation or remediation, we should move to the judiciary or to alternative dispute resolution mechanisms depending on the human right violated. So I'm sorry about the outage and my mismanagement. I apologize for having exceeded the time allotted to me, and I would like to thank you because the idea was to learn about the tool. The tool is not good or bad. The problem is how it's operated, and that is why, depending on every one of our contexts, is key to understand the true scope of this due diligence and whether it's going to be an element that is going to be useful in order to create the necessary guarantees for human rights, or just one more tool to create a checklist or to create reports on the behavior of the companies in order to enhance their international standing. Thank you very much. Thank you, Julian. Thank you very much for your interesting presentation. And finally, we will give the floor to Felipe Enriquez. Felipe is an official of the Undersecretariat of International Economic Relations of Chile, the SUBRE, since 2011. And if you would like, you can read his full bio on the platform. Felipe, the floor is yours. You have 25 minutes for your presentation. Okay, there we are. Can you hear me? Yeah, we can hear you, but your presentation is not on presentation mode. So try stop sharing and share again. Can you see it now? Nope, still no. I believe that you need to choose presentation mode and then share your screen. I see it on presentation mode. But if you want, you can just increase the size and that will work. The percentage you see over there. So can you see it? Yep. From what I see on Zoom, I think it's okay. Thank you so much. Good morning, everyone. Good afternoon as well. First and foremost, I would like to apologize for this technical issue. We actually tested everything before the session started and it was working smoothly, but now technology has turned on us as it usually does. First and foremost, I would like to thank the organizers of this event, of this course, for the kind invitation to present today on this fourth day. As Fernanda mentioned earlier, there are three basic international instruments when it comes to corporate responsibility or responsible business conduct. To supplement what she said, I would like to say that although there are certain differences in these instruments and they have different focuses, they are absolutely consistent and supplementary. So the three of them together constitutes the umbrella that should guide the development of any regulations and public policy when it comes to corporate responsibility. As the national focal point for Chile for OECD guidelines, I would like to focus in particular on this instrument here, one of the three instruments, which is the OECD guidelines. As the two other, this is a soft law industry. That is, it does not set out any binding obligations on companies, but it does provide certain recommendations for the 52 states that have adhered to this instrument and for the multinational companies on different areas that are considered to be relevant because business activities may have a negative impact. So something to be said about these guidelines compared to the other sister instruments, which are the ILO Tripartite Declaration and the guiding principles of the UN. Well, it covers different areas: transparency, human rights, and labor relations. In that case, there's an overlapping with the tripartite declaration: corruption, consumers' interest, science, technology, competence, taxation, and general principles. In every one of these 10 different areas of advocacy, business conduct may have a negative impact, and that is why they have been incorporated to the OECD guidelines. And every one of them may be subject to due diligence. Due diligence generally refers to human rights, and it's only natural because of the extreme significance of human rights and because of the fact that they are so broad in terms of their scope. But every single one of these aspects identified by the guidelines may be subjected to due diligence. Now, I'd like to zoom in on the human rights chapter, particularly considering that it is the subject matter of this course. So let's look at what the guidelines say in their human rights chapter. It says that companies must, first and foremost, of course, respect human rights, also avoid causing or contributing to negative impacts on human rights, as well as addressing those negative impacts, also prevent or mitigate negative impact on human rights, not necessarily caused directly by the company, but also by their business operations, products or services, or by virtue of a business relationship. So this is very much in line with what Juliana and Fernanda said before me, that we're not talking only about the negative impact of the company activities per se, but also the impact that may result from the whole supply chain and their business relations. And this point has a fundamental significance because sometimes it is in the farthest links or in the lowest links of the supply chain that the most serious risks emerge. For instance, it was identified in a country in the north of Africa that is a large producer of jasmine that is used in the production of perfumes. That is a very serious child labor issue. And it is often the families that bring their kids to the jasmine harvest that ends up in the hands of European perfume producers. So those firms in Europe may have very tight control over anything so that there's no human rights violations in their direct activities, but somewhere in their supply chain, there's a very serious risk. And there are, in fact, human rights violations. Another example, cotton produced in a former Soviet Union country is often produced with forced labor, and that cotton ends in apparel produced by very high-end labels that many of us use. Or European nuts used to produce this. I don't want to name any brand, but something that used for pancakes or that is made out of chocolate and nuts. Well, it's been proven that their supply chain also involves forced labor. So supply chain is a key issue when we are talking about due diligence. So what other duties or obligations? Well, no, actually, what recommendations are given to companies to prepare and disseminate publicly a policy setting forth their commitment to respect human rights, as Julian mentioned, carry out due diligence on human rights, provide or cooperate through legitimate processes in the remediation of the negative impact on human rights. And that was also mentioned by Fernanda and Julian before me. And finally, now not talking about human rights, but talking about labor and labor relations in paragraph 1D, it says that companies should contribute to the elimination of all forms of forced labor and adopt immediate and effective measures to eradicate forced labor immediately. As you can see, everything is very much in line with the UN guiding principles and with the tripartite declaration of the International Labour Organization. And on this slide, I'm talking about due diligence, but Fernanda Julian explained it very clearly before me. And what you see there in the chart with the circle and the arrows, that very clearly reflects that due diligence is a continuous process. Why so? Because risks exist constantly and they evolve, they change. Some risks fade away, others appear, and therefore due diligence should be an exercise that takes place permanently.
This slide shows different documents and products that the OECD has developed in order to support implementation of due diligence by companies. First and foremost, we have the OECD guidelines for due diligence for responsible business conduct. That is a general multi-sectorial guideline that wants to support companies with a simple language to put into practice due diligence processes, explaining what we mean by due diligence from the simplest to the most complex, answering different questions that companies may ask themselves, and going through the different stages of due diligence. All these documents might be downloaded for free from the internet, in case you are interested in having a look at them. The OECD has also developed sectorial guidelines considering the specificities of each sector that are relevant at the time of implementing the due diligence. And then we find sectorial guidelines for the mining sector, for the agricultural sector, supply chain, garments and shoemaking, and also for the structured sectors and financial sectors. I would like to share with you some specific characteristics of the OECD guidelines. As of the version published in the year 2000, there is an entity or agency that is in charge of the implementation of these guidelines, and specifically in charge of three aspects: disseminating the guidelines, secondly, guaranteeing the consistency of public policies in each country as regards responsible business conduct, and thirdly, this entity becomes a reparation and complaint mechanism, like an extrajudicial mechanisms to file for complaints, as Fernanda has mentioned. Therefore, every OECD country, there's 38 countries plus 14 countries that adhere or endorse these guidelines, have assumed the commitment of having a national contact point. It says 51, but the Mauritius Islands have recently joined us. In the world, 8 of these countries are from Latin America: Mexico, Chile, Colombia, Costa Rica. They are OECD member countries, and also Brazil, Argentina, Peru, and Uruguay. I would like to briefly describe the characteristics of the national contact points. This is a non-judicial or contagious instance or mechanism. And these national contact points imply a voluntary mechanism, and this is a challenge because companies sometimes draw the wrong conclusion that as their engagement or participation is voluntarily, it's not worthy to engage in the process, and they'd rather use the judicial way or that are more adversarial ways, that this might not be the best way of resolving this dispute. I mean, the national contact points are not arbitrators or court, and we are not oversight agencies, but rather entities whose aim is to support the parties. Therefore, through a mediation or dialogue, they might resolve their controversies or settle them. It is an accessible mechanism. It's non-for-profit. I mean, you can resort to it for free. It calls no need for counsel, legal counsel, or in-person process. It is a simple and flexible stage or instance that the deadlines are not difficult to fulfill, and from the point of view of procedures, is much easier than one that is pursued before a court of justice. It allows for the existence of concurrent or parallel processes. I mean, the same case might be heard in a court of justice, and it can be led simultaneously or run simultaneously by our contact point. And even though the background that is given to the point of contact can only be in the knowledge of the point of contact and the parties, the existence of the case and the result of the case that is then included or embodied in a final declaration, all these elements become public elements, and this is also becomes a sort of an encouragement for companies to be involved, and involved in good faith and in a constructive manner, because their participation or failure to participate, or the way in which they participate, will be included in the final report of the point of contact that is will be in the public domain. Who can submit a case? Any interested party, whether a legal person or an ordinary person, or a group of persons as well. Might be a worker, or a trade union, or a community that is affected by the operations of a company. Can also be a company or an SME that believes it's being affected by the activity undertaken by a multinational company. And why can this person appear before this instance? For example, because they consider that the multinational company is not fulfilling with the guidelines proposed or any of the chapters that I have already mentioned. This slide shows you the timeline of a specific instance before the national point of contact. The first stage is when the initial assessment is performed, when the applicant submits the case before the national point of contact. A notice is sent to the company, if appropriate. We coordinate with the national point of contact of the country of origin of this company, if the company is based in a different country, and then an assessment is made of all the background information to determine whether there is enough ground to provide further analysis to the case, and if there are grounds, the national point of contact would offer its support and good offices to the parties, a space of discussion that can be, or dialogue that can be a settlement, an informal settlement or mediation. Therefore, these parties, based on this dialogue, might find or might try to find a solution to the problem affecting them. Once this good offices stage is over, we move on to the third and final stage. That is the conclusion, in which the national contact point drafts a final declaration, publishes it, and submits it to the OECD for the OECD to post it in its own webpage. In order to conclude now, I would like to show or share with you some statistics in terms of specific stages. In Chile, we have 7 cases open. We've been able to close 32 specific cases. We're about to reach number 40 in our 25 years of service, and in the global national point of contacts, we have already worked and closed about 600 cases. The most recurrent topics are employment and labor relations. In the case of the Chile point of contact, human rights. The most recurrent applicants are trade unions, secondly companies, and the sectors upon which we had to verse upon are mining and manufacturing industry. These sectors and applicants match or somehow match with the global network statistics, except for the fact that in the global network, the NGOs play a very active role as applicants, and an issue that is quite frequently mentioned are the general principles. And this is the case because that is a chapter of the guidelines where the concept or notion of due diligence is better described. In order to conclude, and to supplement what Julian and Fernanda have said, I would like to point out a common thread or common aspect between the 3 international instruments about responsible business conduct. The 3 instruments recommend risk-based due diligence as the right methodology to prevent the negative impact of the business activities on persons, individuals, society, and environment. Thank you so much. Thank you, Felipe, for your presentation, for abiding by the time, and for providing us with so much information and sharing the documents, the fact that they can be downloaded by each of the participants of the course. Now we will move on to the Q&A from the audience. I will address the questions to each speaker, and you will have 2 minutes to answer these questions. The first question is addressed to Fernanda and is about reparation. Reparation to damage is only an economic reparation, or for example, there might be sort of reparation in the case of working conditions, or it's only focused on economic reparation. Thank you so much, Marcia, and the person who raised the question as well. I believe it's a very relevant question in order to clarify what we mean by reparation. Of course, in some cases, there might be some sort of economic reparation or compensation. That is one way. However, it's not the only one, and it's not necessarily the most adequate or the most effective. It all depends on the kind of effect or impact, and in my view, it also depends on the position or stance of the victim or victims. I've been aware of cases in which there have been communities that do not want to be compensated as a community, but they want the reestablishment or return of their land. Some others that have been displaced want to decide where they would be resettled under what conditions or circumstances. Or in other cases, they want a public apology. And in general, it is a combination of reparation measures, not only a single one. Of course, if it is something happening internally in the place of work, this might imply a change of working conditions. I would like to highlight that it is very important not to victimize victims, because when there are cases of labor, sexual harassment, oftentimes this person is changed from position. More generally, the victims are women, they are changed offices, so they are changed positions. In general, they change the situation of the victim and not of the perpetrator or attacker. Then the participation of the victims in the decision making process as to the reparation is key. Same thing happens with the decisions made by the Inter-American Court. There are 4 decisions that have quoted the guiding principles. They are decisions or sentences applied to states, but and they quote our guidelines, and the reparation might be public apologies, memorials, monuments, symbolic reparations, and in some cases, along with monetary reparations or material reparations, but not always economic ones. That's why putting the person at the heart of all the process is very important. Thank you, Fernanda. And thinking of having the person at the heart or at the center of everything, I would like to continue asking, what recommendations can you give us in order to talk to companies, businessmen, trade unions, and workers about this topic? Julian. Well, recommendations. I don't know whether the question is focused on implementing due diligence, but as to due diligence, as both Felipe and Fernanda have mentioned, participation and dialogue is key in any stage. I mean, from the basic, like a company commits itself to having a policy and respect for human rights, to concrete cases in which a risk is identified or an impact detected. Therefore, the engagement or the participation of the different directors or management is very important. However, if the question is more general, like how to create or build dialogue, I believe that precisely that is one of the roles of human rights, something that I will not tire of repeating in any academic or business area or space is that today businesses in democratic states that commit themselves to the rule of law, social rule of law, in no case their freedom is absolute, and therefore free private initiative, the freedom of companies, so the spirit of profit, all these economic variables shall be limited or restrained by human rights. With that, thinking of the workers and the companies doing business today implies assuming that commitment, not only for the sake of responsible business conduct or for corporate social responsibility, but rather, or the way you want to call it, but rather the business activities in the market and the main engines that our companies should be vehicles of well-being, and their obligations need to go beyond fulfilling macroeconomic or economic indicators as to the number of jobs created, the royalties paid, or the export volume. They need to focus on how much well-being they can deliver, or how many rights were protected or facilitated. That is also a bottom line discussion as to the obligations of companies within the framework of the guiding principles, or within the discussion of the binding treaties of companies and human rights, whether they are obligations of failing to do or failing to violating, or whether these should go beyond. And at least in Latin America, under our constitutional frameworks, the fundamental rights demand some other kind of obligations, and that is where the dialogue needs to take place under that scope. Human rights-based dialogue, a dialogue based on international and national treaties, with a view to creating not only labor conditions, the right labor conditions, because today the labor market, the labor world is focused on the decent work or adequate jobs. However, the context of the relations between workers and the activity he or she performs, and the activities performed by the businessmen or those running the company, shall be analyzed under this light. I believe that Latin America has made substantial changes in recent times as regards business culture, and all the way follows all these spaces, and moreover the exercise done by the OECD that used to be thought as a completely economic agency, and most of its work is thought as to understanding human rights and facilitating this, and this is also seen by the work of the ILO.
With these tripartite declarations and this creation of spaces and beyond the labor relation, to start thinking of human rights and dignifying work at present. Thank you so much, Julian. I have another question here for Felipe. So, how can national focal points facilitate responsibility on the part of companies when it comes to violation of human rights in international supply chains? Thank you so much for the question. Your mic is a little bit low. Can you hear me better now? Thank you so much. I was just saying that if an interested party considers that a company is not doing enough to prevent violations of human rights along their supply chain, they may bring the case to their national focal point. Actually, if the country where these human rights violations take place, there's no national focal point, but the company is registered in an OECD country, they can perfectly bring a case before that national focal point. And the focal point can act as a facilitator of the dialogue between that party at interest that has brought the complaint. That could be, for instance, an NGO and the company, in order to reach an agreement that will allow to compensate that damage that has been caused and also to prevent further damage in the future. And Fernanda explained that extremely clearly a while ago, that reparation can go far